Good day, our esteemed viewers, listeners, and subscribers of Ascent Litigation Radio, and welcome to another interesting day in classroom and on radio. I remain your host, Barrister David Ono Njoko, and today on Ascent Litigation, we'll be discussing a very important and topical issue that is on the front burner of Nigerian politics today, which is the statement by the FCT minister. By FCT, I mean the Federal Capital Territory, Abuja Minister, Chief Barrister Ezebumonyesom Wike, who made that statement on the 21st of August 2023, where he stated that if your land is not being occupied or is not being developed as at when you were given the certificate of occupancy, that certificate of occupancy will be revoked because you are doing land racketeering. And then it has sparked some reactions and some apprehensions on the minds of landowners in Abuja who are in the habit of land speculation, where they will buy land at a cheap rate and they will leave it for development to come to that very area within the next 5-10 years, and then the land appreciates to a level that is unimaginable, where they will not make money out of it. Maybe you buy a plot of land at the rate of 500,000 naira today, somewhere in one of the interior areas of Buhari district in Abuja, and you leave it for the next 5-10 years, and the federal government decide to site an institute within that Buhari area. It definitely will appreciate the value of that land, and then that land you bought 5 years ago at the rate of 500,000 per plot, you will be selling it at the rate of 10 million naira 5 years later. That is making a profit of 9.5 million naira. Wow, what a wonderful way of making money. And that is what people do when they do land speculation and land racketeering. And then that is what the minister wants to sanitize. And then we ask the question, does the minister of FCT, does he have the power to revoke certificate of occupancy of Abuja landowners? That is our topic for today, and I believe you are already excited because you want to learn in classroom today, and that is what we do here in Ascent Litigation. So first of all, let's understand what is the scope of the powers of the Minister of the Federal Capital Territory, Abuja. Now, the scope of the powers of the minister, it doesn't exist in vacuum. It is a creation of the law, because the office of the Minister of the Federal Republic of Nigeria is a creation of Section 147 of the Nigerian Constitution. Remember last week we talked about the powers of the president to appoint ministers and distribute them to or assign them to any ministry of his choice. And then we emphasized there that the FCT minister is one of the ministers that the president can appoint under his powers in Section 147 of the Constitution. So, having been appointed, what now are the powers of the FCT minister? Number one of his powers is the powers to carry out all functions of the chairman of the Federal Capital Development Authority. Now, what this means is that the FCT minister can delegate or decide to abrogate to himself all powers of the chairman of the Federal Capital Territory Development Authority, which is in charge of building controls, building licensing, building fitness, and all that. He has the powers to either assign those functions to the chairman or to abrogate them to himself. That is within his statutory powers under the Federal Capital Territory Act of 1986. Also, he has the powers vested in the president in accordance with Section 299 of the Constitution relating to Abuja. Now, what does Section 299 of the Constitution says? It says that all lands within the Federal Capital Territory shall be administered by the federal government headed by the president. That is to say, by virtue of Section 18 of the FCT Act, the president now assigns all these powers he has under Section 299 of the Constitution, which is the power to administer all lands within the Federal Capital Territory. The president now assigns it to the Minister of the Federal Capital Territory. So then what does it mean to administer lands in Abuja or in the Federal Capital Territory? Now, what it means is that you have the powers to issue licenses to people for the purpose of land development or property development. You have the license as the Minister of the Federal Capital Territory to issue certificate of occupancy to members of the public who purchase land and want to develop that land or want to use it for agrarian purpose or for commercial purpose. And then you also have the powers to endorse on instruments of land, that is instruments or documents which transfer title of landed properties within Abuja from one person to another. Remember, for those who have already gotten property, in our property transaction sections, we have always talked about deed of assignment, which is the ultimate document for you to purchase landed property anywhere in Nigeria. Now, in that deed of assignment, there is a particular portion which is meant for the governor's consent, and that portion has to be signed by the governor. And now, what that governor's consent means is that, in accordance with Section 1 of the Land Use Act, all lands within the state is vested in the powers of the governor of a state. Now, this is the same thing with what Section 299 of the Constitution has provided, that all lands within the Federal Capital Territory is vested with the federal government headed by the President, of which the President has now delegated the Minister of the Federal Capital Territory, by virtue of Section 18 of the Federal Capital Territory Act, to now administer this land. That means the same powers which the governors have under Section 1 of the Land Use Act is the same powers that the Minister of the Federal Capital Territory has under Section 299 and then Section of the 1999 Constitution and Section 18 of the Federal Capital Territory Act of 1986. Now, having established this, we go further to understand that the Federal Capital Territory Minister equally has the powers to administer all laws that are stated in the second schedule of the Federal Capital Territory Act. Now, the second schedule of the Federal Capital Territory has over 77 laws in it, which the minister has the powers to administer, inclusive of subsequent laws that will be made by the National Assembly with respect to the Federal Capital Territory. Now, one of those laws, one of those 77 laws, is the Land Development Law of Abuja. That is to say, the minister has the powers to administer the Land Development Law. What does the Land Development Law of the Federal Capital Territory mean? It means that the minister has the powers to sign on the documents that is issued to developers for the purpose of land development or improvement in Abuja. Another law related to landed properties in Abuja under the second schedule of the FCT Act is the Land Registration Law. Now, the Land Registration Act, rather, provides that it is the FCT minister, just like the governor of each state, that has the powers to consent to transfer of ownership of land from one person to another in Abuja. Now, that means that you cannot transfer, you cannot purchase land in Abuja and then you now claim to be the owner of that land in Abuja without the consent of the Minister of the Federal Capital Territory. So if you have a landed property in the Federal Capital Territory, in any of the 6 districts of the Federal Capital Territory, and you don't have a document where the Minister of the Federal Capital Territory is the one that endorsed on it that you are the real owner of that land, then you just know that what you just have is a piece of paper, and according to the law, you are not yet, in the eyes of the Minister of the Federal Capital Territory, the rightful owner of that property. Now, having established the powers of the Minister of the Federal Capital Territory, we will now go into discussing the fulcrum of our discussion today, the Certificate of Occupancy. What do we mean by Certificate of Occupancy? Now, Certificate of Occupancy is a creation of the law. What the law that provides for Certificate of Occupancy is the Land Use Act of 1978. Now, prior to the enactment of the Land Use Act of 1978, what we had then is a situation where landowners are the alpha and omega of land. That means when you own a land, you have the right to use the land whatsoever way and mode you desire. And if the government will want to make use of that your land, the government will have to pay heavily whatsoever amount you decide to sell the property to government. That is what happened before 1978. But by the advent of the Land Use Act of 1978, just as the word says, Land Use Act, not Landowners Act, it now provides that every person that occupies any space of land, the highest means of ownership he has is the right of use, right of usage, and not right of ownership. That is the highest document he can have. The right of usage, and not right of ownership of the land. Now, what this means is that you may now ask yourself the question, does it mean that if I purchase a property, I'm no longer the owner of the land? I'm only permitted to use the land and not to own the land. Now, the intent of the Land Use Act is to the effect that once you are in possession of any land, you are now authorized to use the land in accordance with the document which is called the certificate of occupancy that you'll be issued. Now, your certificate of occupancy will now state that you are to use the land for commercial purposes, which includes building of office spaces, or you are to use the land for agrarian purpose, which is farming, or you are to use the land for grazing purpose, okay, or you are to use the land for industrial purpose, or you are to use the land for mining. That is what the certificate of occupancy will state. And once it says that you are bound to use the land in accordance with the conditions upon which the certificate of occupancy is issued to you. Now you just imagine that whenever I state certificate of occupancy, I always use the word issued. That is because a certificate of occupancy is a document issued to a person in possession of a land, showing that the person has to use the land for a particular purpose as stated in the certificate of occupancy. Now, the law is clear on this. Issuance of certificate of occupancy does not automatically mean that you own that land. What it only means is that you now have the certificate showing that you are the one in possession of that land, and therefore which you are given the possession for a particular use or specific use as stated in the certificate of occupancy. Now, what actually shows that you are the owner of the land is what we call rights of occupancy. There is one between right of occupancy and certificate of occupancy. Right of occupancy simply means the full proof that a person has been granted the right to own that piece of land and to use it in accordance with the stated use as indicated in the certificate of occupancy. Now, what this means is that for you to own a certificate of occupancy, you must first have the right of occupancy of that property. So let's say Mr. Tunde bought one plot of land within the Asokoro axis of Abuja. Now, upon signing the deed of assignment, which is the document we use in transferring title from one person to another, or sale of land, upon signing the deed of assignment, Mr. Tunde is meant to take that deed of assignment for the purpose of registration. He registers it with the Federal Capital Development Authority. And then he will now go ahead to stamp that document with the Ministry of Lands, with the Lands Registry rather, of the Federal Capital Development Authority. Afterwards, he will now apply for the consent of the Minister of the Federal Capital Territory, which is something as the consent of the governor for lands in the states. Now, until that happens, that consent is given, which is not showing that he has statutory right of occupancy on that property. He cannot apply for certificate of occupancy of that land. So your right of occupancy must come before your certificate of occupancy. That's to say, you cannot have a certificate of occupancy if you don't have a right of occupancy. Then we may have a situation where people will just go meet bypass the process, meet the FCT minister to sign certificate of and issue them certificate of occupancy. What that means is that despite you have a certificate of occupancy, you are not the owner of the land, because as we said, certificate of occupancy does not show ownership, rather it only shows usage of the land. What shows ownership is the right of occupancy, which is usually statutory for the purpose of Abuja. Now let's dive deeper into this discussion. Having seen dissected the powers of the Federal Capital Territory Minister under Section 18 of the Federal Capital Territory Act, which one of it is the right to issue certificate of occupancy and then act with respect to the powers of the president under section 299 of the constitution with respect to administering lands in Abuja. One of the incidental rights, by incidental right I mean one of the rights that flows from the right of the president to administer land, is not just right to issue certificate of occupancy, but equally right to revoke that certificate of occupancy. And we can see this for issuance of certificate of occupancy under section 9 of the Land Use Act. Then under section 28 of the Land Use Act, it provides for revocation of certificate of occupancy and instances where that certificate of occupancy can be revoked. Now, understanding that you cannot have a certificate of occupancy except you have statutory right of occupancy. When certificate of occupancy is revoked, that doesn't automatically mean that your right of occupancy in that property has been revoked. That is not the case. What is only revoked is the evidential proof that you are allowed to use that property or that piece of land for a particular purpose, for which usage is for 99 years and not more than that. Now, if that certificate is revoked, you still have your statutory right of occupancy that inures in you as a result of you purchasing the land from another person and then you now being in possession of the land. Remember, for you to prove title to land, there are different ways to prove title to land. One of it is title documents, another is act of ownership, another is act of long possession, another is traditional ownership, which is you stating how you got the possession of the land. Maybe your grandfather migrated, came to that land, saw it as virgin land, occupied it, and then you inherited it from your great-grandfather, who inherited it from your grandfather, and then so on and so forth until it got to your time when you now inherited the land. So if your document title is being revoked, which is certificate of occupancy, it doesn't take away your right to own that property as a result of act of ownership. Possibly you have built on the land and you're living and you're staying or habiting that land, piece of land. So certificate of occupancy is not a full proof of ownership of land, for which revocation will now automatically lead to revocation or extinction of the rights of the owner on that very land. So when people are jittering because this FCT minister said he's going to revoke certificate of occupancy, some of us laugh because that certificate of occupancy only when you revoke it, you only revoke the proof that the person owns the land. You don't actually revoke his title, his interest in the land, as his interest still remains, for which he can proceed to court and then challenge your revocation, and then whatsoever overt action you have done as FCT minister to reclaim or repossess that piece of land that he owns. Now, having established this, it is important that you, our viewers, understand that under our inherent laws, the FCT minister has the powers to issue certificate of occupancy as well as revoke that certificate of occupancy. But in revoking that certificate of occupancy, it must be under the due process of law, because there are conditions under which he can revoke the certificate of occupancy. Number one of that condition is that the government wants to use the land for public purpose. And what amounts to public purpose is maybe the government wants to construct a road along that very portion where the land is located, or the government wants to build a health facility or a school or anything or any public infrastructure on that very land. Then the government can acquire the land and revoke the certificate of occupancy and then acquire the land by paying adequate compensation on the owners of the land. This brings me to what happened just yesterday, being the 30th of August 2023, where the FCT minister was seen, where he announced that along the corridors of the Lugbe Airport Road highway in Abuja, the federal government wants to dualize that road, for which it's a 4-kilometer road, and owners of land along that 4 kilometers will be affected and their houses will be demolished. And then a compensation of about 853 million naira of that was issued as compensation to the community leaders. The question is, does that amount to adequate compensation? And paying to community leaders, does that amount to adequate compensation to the real owners and holders of certificate of occupancy or statutory right of occupancy of a land? The answer yes is no, because where communities have sold their community land to individuals. That land is no longer a community land, but now becomes private property of individuals that have bought the land. And where they have improved on the land, they are the ones to be compensated for the usage of that land for the purpose of public use, and not the community. So the minister has to restrain his steps and then go back and meet with the real owners of the land if those land along the 4-kilometer highway of Lugbe Airport Road does not belong to the community but has been sold, or any portion of it, even though there are some portions that may belong to the community, but any portion of it that belongs to individuals, those individuals must be you must have a separate meeting with those individuals, and then adequate compensation must be paid to those individuals and not to the community. If you don't do that, you will be going against the spirit and letters of the Constitution, which provides in Section 44 prohibits all acts of compulsory acquisition of land by the government or by individuals, because land is one of the rights. Right of property or right to ownership of land is one of the rights, fundamental human rights under our Constitution, and cannot be derogated upon. Having established this, we equally want to advise residents of Abuja, that is the Federal Capital Territory, to remain law-abiding, and where their land's certificate of occupancy is being revoked for whatsoever reason, because the certificate of occupancy the revocation notice must state the reason for such revocation. If the certificate of occupancy was issued and then one of the conditions is that you must develop that property within 5 years, and you're yet to develop that property, then the revocation will be legal. But if the property was issued for the purpose of for agrarian purpose, and then you are still farming on the land, you didn't build on the land, you're just simply farming on the land, the FC minister has no right to come and then revoke that certificate of occupancy, because the condition upon which it was given was for agrarian purpose and not for commercial or residential purpose. And as such, you can approach any of the high courts in the Federal Capital Territory or the Federal High Court for the purpose of ensuring that you entrench your right to ownership of property and the right against unlawful acquisition of property by way of revocation by the minister or any other person acting in that capacity. Having established this, we urge each and every one of us to be law-abiding, pray for Nigeria, and always do what is right. Once you have your certificate of occupancy and you are supposed to develop your land within a specific period of time, go ahead and develop the land. If you have your certificate of occupancy and it was issued for residential or commercial purposes, make sure that the development on that land is for that purpose and not otherwise. Otherwise, if they revoke your certificate of occupancy, then your rights to usage of that land automatically extinguish. Please, if you want to read more on this topic, we have our article on our website, www.lawassent.com. Go there, click on the resource icon, and then you will see the write-up of this very topic. As usual, we always want to get your comments, feedback, suggestions, and questions. So do well to leave such at the comment section of whatever streaming platform you're listening to us or watching us from, and we'll always give you prompt response. Until we come again your way next week with another interesting topic, because this time around we will still be centering on the ministers, but this time just one minister because of certificate saga. Until we come again your way next week, remain blessed and keep praying for Nigeria. Thank you and God.